Okay, good evening, folks. It is now 7 o'clock. Welcome to the webinar for legal help, what to do when facing death. Brett Kepley here at the Champaign Public Library, and of course I'm hosting Brett from the Lincoln Legal Aid Group. My name is Kat Purcell and I'm a library associate here. I want to thank you again for joining us. For the latest library news and updates, we invite you to visit our website at champaign.org. You can always follow us on social media on Twitter, Instagram, and Facebook. If you'd like to contact us, you can email us at librarian@champaign.org, or you can chat with us by just visiting the homepage of our website. If you're unfamiliar to Zoom, I'm going to go over a few features that might be helpful to you during this webinar. There are some icons at the bottom of your screen, depending on whether you're on a computer or a tablet or phone. So you'll see at the bottom left, you'll have the option to control your sound or your speaker. Next, moving to the right, in the center window includes a chat box and a raised hand option. You can use these options to ask questions or share any comments. Our presenter tonight is doing presentation style, so he is welcome to ask, you're welcome to ask him questions at any time. So if you want to put them in the chat box or hit that raised hand button if you're more comfortable, I'll go ahead and unmute you. So if you see the chat box, you can choose to ask your question there. You can choose to ask to just panelists, or you can raise your hand and we'll unmute you so you can ask your question. Please remember that this webinar is being recorded, so be mindful of that, and we will try not to use any names when I'm asking questions on behalf of customers for that reason. With that out of the way, I'm going to go ahead and introduce Brett and turn it over to him.
Thank you. Yeah, I am an attorney with Land of Lincoln Legal Aid in Champaign. Land of Lincoln Legal Aid is a not-for-profit foundation, and its mission is to provide legal counseling and representation to low-income individuals. And we cover a wide area of the law. It's all civil litigation or civil matters. We don't do any criminal matters. That's obviously what a public defender does, but we can handle matters involving housing, evictions, homeownership, foreclosures, senior issues, including being admitted or discharged from care facilities, doing wills, assisting in government assistance programs where you're trying to get Social Security or veterans benefits or disability benefits or other public assistance. And we do an awful lot of family law and involving primarily domestic violence that is involved in child custody and or maintenance parental control. So those are some of the things that we do. And tonight I will be talking about the field that I do most of my work in, and that's debt and bankruptcy. And so that's what we're going to be talking about, is dealing with debt, and have a little bit of a dissertation on what the heck bankruptcy is all about. So what I'm going to do, and I've got a PowerPoint, I'm going to start up and see if that will go. And it's slowly formulating. Let's see if we can get this thing going as it should. So, can you see the entire screen filled with my PowerPoint?
Yeah, we've got your whole PowerPoint there, and it does pop a little window of you off to the side there. But
exactly. Yeah. That's to make sure that this is not a recording. I am, in fact, a live Android who is talking to you from the Land of Lincoln office. By the way, if you're interested in contacting Land of Lincoln, when I get to the end of the PowerPoint, we'll have contact information. Land of Lincoln legal aid covers not just Champaign. It goes, we cover about 65 counties in central and southern Illinois. So it's a gigantic area, and we actually have about 5 offices with a couple of satellite offices. But the one nearest to you folks who might be watching this is in Champaign, and we're located on 302 North 1st Street in Champaign. And we have an 800 telephone number. So if you've got problems on the topics that I talked about, and if you are income qualified, you can call in with your problem. And if you get qualified, then we can start representing you. And so tonight we're going to be talking about dealing with debt and bankruptcy. Everybody gets into debt of one sort or another, usually loans to help them get things that they cannot afford to pay for all in one shot. You know, if you want to buy a home and you're not cash heavy like Elon Musk, then you're going to have to get a loan, and that puts you in debt. You use a credit card for convenience in exchange for having a giant wad of cash in your pocket when you go to the gas station. Use a credit card. That's getting in debt. So we all get into debt, and the question is, what happens if we get snarled in trying to deal with it? Or even if you're staying okay, we're going to talk a little bit about the different kinds of debt and how to treat it. And so that's what this window here is talking about. What kinds of debt are there? Under the law, there are principally 2 major kinds that you would incur. That is secured and unsecured. And you see the little house on the left with the for sale sign. That would be a situation where if it's secured, that means the creditor, that's the person that you owe money to, has rights in a certain property. They will have those rights either by virtue of your agreeing to give them rights or sometimes by operation of law. So a typical thing where you agree to give rights is a mortgage. We all hear the word mortgage, and that means you get a loan to buy a house. The bank is loaning you money. So why would the bank loan you money? Because you may be at risk in not paying it back. You give them a mortgage. That means you sign a document that gives them legal rights in your home. You're still the homeowner. You're going to be ending up the homeowner after the real estate closing that you got the money to buy the house with. But they have a right in that house, and that is if you default on that loan, then that creditor can come in and exercise their legal rights to take away the property. And that's done for the purpose of paying the loan or paying some of the loan. So when you have a house that you gave a mortgage on, and if you default on that loan, they can, through the legal process, the creditor can try to put that house up for sale. And we'll talk a little bit about that later on. So that's an example of secured debt. Another common one, very common, is if you're financing a car. So if you buy a car, again, you're signing an agreement that in that loan agreement to that creditor to give them rights in the car. That would be secured. What's an unsecured loan? That's where you just owe the money. The creditor doesn't have rights in any particular property that you have. You owe the money. So they can't really do anything until they take legal action against you to possibly have a right in any of your property. They have to sue you first and get a money judgment. What's a money judgment? That is a declaration of law that you owe money. So then when you have the declaration, then the creditor can try to take the property. Until they win the lawsuit, they ain't going to be able to get any property as a general general matter. All right, we talked about secured debts. We have car loans and mortgages. If you default on a car loan, under Illinois law, and that's what I'm principally going to be discussing because I'm not familiar. Every state has its own laws regarding debt and creditors. There are federal laws that affect that too, but the principal operation of almost every state is under state laws. And in Illinois, a car loan creditor, if you default on the loan, that means what? You miss a payment. You don't keep it insured. You wreck the car. There's a whole bunch of terms in your car loan on what is a default. And if any of those defaults occur, then the creditor has a right to ask that all of the unpaid amount on that loan becomes immediately due and payable. And so if you can't pay it off, what do? They have a right to seize your car, and they can do it. They cannot break into your garage, but they can pluck it off the street, possibly pluck it out of your driveway. They just can't disturb the peace about it. They could take it out of the parking lot at work if they knew where your car was at. So that's one of the common areas where a creditor can take the car, and what they do then is they put it up for sale, and they have to send you notice about the terms of the sale, when the sale is going to be had, because who knows, maybe you've got a friend that could come in and bid at the sale and pay the loan off. If the car is sold at a sale and it doesn't pay the debt in full, you're going to be on the hook for the shortfall. Same thing on a house and mortgages. If you default on a house, it can be taken and sold. However, there's a lot more legal hoops the creditor has to jump through. They have to sue you in court. It's called foreclosing on the mortgage. They cannot take the house. They can only do it under court order. And you are given a lot of time under Illinois mortgage law to come up with the money, either to cure the default you're in, or at least come up with the money to pay off the mortgage debt before the creditor can put the house up for sale. But if you don't, you get sued. They get a judgment for foreclosure, court order, allowing the creditor to take the house and have a sheriff. And these are conducted typically by the sheriff. They're called sheriff sales, and they're done in a public auction, usually at the courthouse. And then people come in and bid on it. Usually the mortgage lender will bid their own debt, and they become the owner of the home. To the extent that they submit their bid as a winning bid, that is a credit given to the debtor. So those are very common types of secured loans for mortgages and cars. Unsecured debt, there's a ton of those. Personal loans, payday loans, credit cards, that's a debt. You use your credit card the instant you buy your Christmas present for your beloved mother, and you use the credit card. The credit card has extended credit, and so you owe that credit card. Now the debt may not become due until next month's billing, so you're okay, you're not in default. Utilities, and that's another common debt. If you fall behind, you get the bill every month, you pay it, or every other month, like with a water bill, and you pay it, fine. If you don't pay it, utilities have one thing that all these other creditors that I talked about don't have. Even if they are unsecured, they have to sue you. Well, a utility company might not sue you to get a declaration that money's owed. They will simply shut off your power or your water or whatever the service is. And they have to give you a notice ahead of time before they can do that, to give you an opportunity to come up with the money or work out a deal. And some utilities will work with you if you have fallen behind on the bills, and that might be you lose your job. So how are you going to pay the bills? Maybe you hold off on paying that utility bill because you got to pay your rent, or you're making a car payment. You don't have enough money to pay the utilities. So then you fall behind. Then when you start generating income again and utility companies threatening to shut off, maybe you can do a deal. I know some of the local electric companies in Central Illinois will deal with you. Now, if the debt gets too big, then they might draw the line on coming up with a payment plan to work out. And the point of all this is if you don't work out a plan, you're going to lose your power, unless some other remedies we'll talk about in a second on bankruptcy. And by the way, if you do default with a utility and they cut your power off, as long as you owe money on that account, that utility does not have to hook you up ever again. So somehow you got to figure out how to permanently resolve it or not use that utility. So that gets us to how you resolve debt that you're behind on. Number one, pay it off. Obviously, if you're behind, there's a reason, and it might be, as I said, you lose your job. That's a common one. Another common one is you get divorced. You and your spouse together had the income to afford to make the payments on whatever you're paying on, and then all of a sudden you're split up and you're on your own, and now we got a problem. Maybe you can't make that car payment without the soon-to-be ex-spouse. So then paying off is not as easy. But there are ways. One way, and this blends into that second point that I have here. So we have pay off, and then we have settle for less than the whole amount. And there are outfits that are companies that resolve your debt for you. And so what you do is you contract with them, and they negotiate with all of your creditors, and they try to come up with a payment plan with each of those creditors such that that company then says, I need X amount of money from you each month so we can disperse it to the creditors. And so they say, I need $200 from each month. So you pay that. And under your agreement with them, then they say, we're going to need $200 a month for 18 months. And when we do that, we're going to have all your creditors paid off. That's because the company, the debt resolution, they're often called debt consolidation firms, have worked out a deal where they're paying the debts in part, at least. If you're going to settle with a creditor, that's for less than the full amount. That's good. But it's nice to get that pledge in writing, because the left hand doesn't know what the right hand is doing on some big institutional creditors. So if you're talking to somebody on the phone, if you're talking to Discover Card and they're willing to settle for less than the whole thing under X terms, and you're all pleased, so you hang the phone up and you start sending in the payment for the X terms talked about, and then after you've paid it off, you're getting a letter for the balance. And you're going to say, hey, wait a minute, I thought we had a deal. Now, how do you prove it? The best way is you get it in writing. You get a confirming email, you get a confirming letter, you send maybe a letter and an email. If it's hard to get those banks and those creditors to write you back, and you say, I confirm our phone conversation this date in which we agreed that you will discount my $4,000 debt by 75%, and I will pay you $500 a month on the first of each month starting next month. You send the letter in, and then you start making your payments. So if they then come back down the road disputing that and say, hey, here's a letter, I sent it to you, you did not respond, and so under the law, that could be construed as an admission by you as to those terms. Get it in writing, whatever the settlement is. If you're writing a check, I make note here, you can write on the memo line settled in full. And if they cash that check under the law, they are bound by those words. So that's a big factor. And when you write settled in full, put your account number on there so we can identify what the heck you're settling it to. Finally, another way that debt gets resolved is simply the creditor writes off the debt. They're done with it. They're not going to pursue it. They're not going to assign it to somebody else. There are debt buyers out there, companies that will buy the debt that is held by another creditor. So that debt buyer steps into the legal shoes of the previous creditor. And so they can sue you. They can bug you and hound you. Maybe now they have the lien to take the car if that original creditor didn't want to do it. They step into all those rights. So being written off by creditor doesn't necessarily mean the debt is gone. It's got to be a write-off where they say we're canning this debt and we're not going to do anything more with it. There could be one problem with that though, and a lot of financial institutions will do this. If you got a loan from a bank, is they can report it to the IRS that they are just writing off the debt. And if they do that, that debt amount write-off could be included as income tax by the IRS. Now, if you had a defense to a bona fide dispute about the debt, and they decided to drop it because of the dispute, that is a defense to the IRS claim that it's taxable income. Those are some of the issues of resolving debt. And what if none of that works? You can't afford to pay it off. You can't work a deal with the creditors. They won't write it off. Can't settle in part. There is a nuclear option, and that's called bankruptcy. Bankruptcy is a federal law. There is a federal code. It is controlled by Congress that writes the bankruptcy law. And there are federal courts that are called bankruptcy courts. And that is where you file a bankruptcy case to start your bankruptcy. And the purpose of the bankruptcy code and bankruptcy law is to help debtors resolve debts with their creditors. You hear chapters, there are different chapters in bankruptcy, and that's a term of art and a term of the law that's used, and that's because the bankruptcy code has different sections in it for different kinds of bankruptcy cases. So that's when you hear the words chapter all the time. And what are those chapters? We have, the first one is chapter 7. This kind of a bankruptcy, which is the most common, that's filed in the United States, is called liquidation. That is where you file the bankruptcy, you're going to get your debts wiped out, and if you have any property that's available to be distributed to your creditors, the bankruptcy court will seize and distribute that property. If you don't have any property available to be taken because you're allowed to keep certain property under the law, then you don't lose that property. You go into bankruptcy, the debt gets wiped out, and you get to keep your furniture or your car or your clock or whatever. You're allowed to keep a certain amount. By the way, the Chapter 7 bankruptcy can be used for discharges only once every 7 years, or 8 years, excuse me. It used to be 7. Congress booted it up to 8. So if you've already filed and got a discharge, you got to wait 8 years from that original filing date in order to file again. Also, Chapter 7 has a limitation. If you make too much money, you do not qualify. And there's a chart and a complicated formula for that, which you probably need to talk to a bankruptcy lawyer if you're thinking about filing bankruptcy. You may not qualify for a 7. But if you do a 7, or frankly, any bankruptcy, what are examples of things you get to keep? You get to keep in Illinois. This is under Illinois law, which bankruptcy code allows. So you can use Illinois state law for your exemptions to see whether you lose any property in bankruptcy. You get to keep $4,000 in any personal property, 24 in a vehicle, all retirement or pension income, all Social Security, all veterans benefits, disability, life insurance payable to a dependent. If you have a home, you get to keep $15,000 in the value of your residence that you're using as a residence. So if you have property within all these things, then you're not going to lose anything when you go into a Chapter 7. These exemptions, and this is what gets complicated. Again, you're going to have to talk to your bankruptcy attorney, but these exemptions I just cited are Illinois exemptions. If you're filing bankruptcy in Illinois, but you lived in a state other than Illinois in the previous 2 years from the date you filed your bankruptcy, you have to look at the exemption laws of that state. Now, if you went if you filed a bankruptcy in a bankruptcy court in Indiana, but you had lived in Illinois within 2 years of the Indiana filing, then that Indiana bankruptcy court is going to be looking at your Illinois exemptions, the ones I just gave you. So this all gets, there's no clear answer to all of this, and that's why you just got to ask your bankruptcy lawyer, what do you get to keep and what do you don't. When you file a Chapter 7, I said your debts get wiped out. Not all debts get wiped out. The common ones that do are like credit card loans, personal loans, bank loans, your car loans, maybe even your house loan. Your personal obligation on those loans gets wiped out in the bankruptcy at the end of the Chapter 7. There are exceptions, and criminal fines are not wiped out. Recent income tax is not right. Now, if you got really old income tax, older than 3 years, 4 years, and it's income tax, and you timely filed your returns during those tax years, those older income tax debts can get wiped out. Money owed to your ex-spouse in a divorce. If there's a divorce judgment entered, where the judge orders you to pay the spouse some money, maybe for maintenance, maybe as a trade-off on a house, that kind of debt to that ex-spouse will not be wiped out in any kind of a bankruptcy. Now, I talked about Chapter 7. Here's another one, Chapter 13. This is one where you might use it. If you're going to lose property in the Chapter 7, because you got too much property over the exemptions, you can use a Chapter 13. This is a different kind of bankruptcy. This is where you got to come up with a plan to repay the creditors on a monthly basis. And at the end of the plan payments, whatever debt is not paid in full can get then wiped out. So if you owe $50,000 to a credit card and you couldn't possibly pay that, and you don't want to file a Chapter 7 because you got this car that's worth $20,000, and you don't want to lose that car because you don't have enough personal property exemptions. Maybe you can only exempt, $10,000 of it, which means the bankruptcy court, if you filed a 7, would be interested in taking that car, selling it. You get your $10,000 of exemption out of it, or $5,000 or $2,400 or whatever it is. The rest goes to your creditors. Well, to avoid that, you can go into a Chapter 13, and under that plan, you would pay as much as that creditor would have gotten in a Chapter 7. That way, you get to keep your property. Now, the trick here in a Chapter 13 is no plan can last longer than 60 months. And what are you paying under the plan? You have got to pay all your disposable income. That is all your after-tax income minus your living expenses. And those living expenses is what Congress says they are, not what your actual in fact expenses are. Now, there are some exceptions that you can show, but excuse me, otherwise you got to pay all of your disposable income, and you got to do it every month. The plan has to be approved by the bankruptcy court, and there's a lot of conditions to doing that. If you cannot come up with a plan that pays your creditors as much as they would have gotten in a Chapter 7, then your Chapter 13 plan is not going to work, and it's not for you. What choice do you have then? Chapter 11. Chapter 11s are for individuals. You hear about it all the time for corporations. And by the way, corporations can also file a 7, but they won't get a discharge. Corporations are only filing a 7 basically to have a bankruptcy court help them liquidate all of their property. So, but Chapter 11s an individual can file. The plans are more flexible. They're not, limited to 60 months. You're still going to have to pay as much under a Chapter 11 plan as creditors would have gotten under a Chapter 7, but you can expand the time and terms. The problem with an 11 is two things. One, it is really expensive. The filing fee is well over $1,000. You have to pay quarterly, another fee based on what your income is. And so it can be very expensive. The other problem with the 11 is you have to have the plan approved by at least some of your creditors. They have to vote on it. You send out ballots, just like an election, just like electing your student council president, your homecoming queen. So they got to mark these ballots and send them back. And if you don't get the proper amount of passage, the plan is not going to be approved. But at the end of the plan, or not at the end of the plan, in Chapter 13, the end of the plan is where the discharge comes. If you get a plan and it gets confirmed, the plan itself can say the unpaid debts that are not going to be covered in this plan are discharged. That means wiped out. So that's the benefit of a Chapter 11. And that's what you hear. Corporations use it all the time, from airlines to bakeries. Because corporations cannot file a 13. So the only plan they could do are 11s or Chapter 12. Chapter 12s are for farmers and fishermen. You got to have more than half your income applied, or at least half your income applied or coming from agricultural operations or fishing operations. But you can have a plan, can restructure the debt repayment and discharge of debts that are provided for in the plan, just like in a Chapter 11. The Chapter 12 was really designed for farmers. It's a little more expedient, a little simpler, not much, from a Chapter 11. So whatever kind of bankruptcy you're filing, it puts a halt to creditor collection. They cannot write you letters, cannot sue you while you're in bankruptcy. If they're in the middle of a lawsuit, that lawsuit has to come to a halt. And the only way they can proceed is to ask permission of the bankruptcy court to do it. Or there's provisions in the bankruptcy code that does allow creditors to proceed, but they're very limited. For example, if you're in a divorce, the divorce case can proceed to get divorced. Bankruptcy doesn't stop that. It will stop, however, the family law judge from dividing up the property and giving the house to the Mrs. and giving the motorcycles to the Mr. Bankruptcy judge can't do that. The parties can't ask them to do it while one of those parties that owns part of the house and those motorcycles is in bankruptcy. So you got to get permission from the bankruptcy court to proceed. And here's one big thing. I talked about wiping out debt. in bankruptcy. One thing Chapter 7s don't do is they don't wipe out the liens. That is the rights of the secured creditor in the property. So if you gave rights to the car lender, for them to be able to seize that car, it's called a lien. That lien does not get wiped out in the bankruptcy. So if you file a Chapter 7, that might wipe out your personal obligation to pay that debt. But they can still come and fetch the car after the bankruptcy is over with. Liens can be resolved, eliminated, pared down entirely or in part under Chapters 11, 12, and 13 plans. So that's the other benefit of those plans. The difficulty of being in 11, 12, and 13 is what? You're stuck in a plan. That can affect your credit rating. You're in limbo. So if you want to go out and get a new car loan, you might be able to do it, and you could well do it in the middle of a Chapter 13 plan. And by the way, when you're in these plans, you have to ask permission of the bankruptcy court to go out and get a loan to buy a new car. But otherwise, if you're just trying to build your credit up, it's going to be in limbo when you're stuck in these plans until the plans are over with and the debts have been discharged. So that in a nutshell is dealing with default in debt, what kinds of debts there are, and how you might go about trying to treat them, and what the various bankruptcy options are. It is complicated. Bankruptcy law is really a snarl of minds, and it uses a lot of forms, and there are people that you can print out bankruptcy forms from the bankruptcy court websites. You can do a bankruptcy by yourself. But boy, it may well be worth the money to hire a bankruptcy attorney, because it can really be a snare. And you want to try to protect your rights as much as you can, keep your property and minimize the amount of debt you have to pay. And there are ways to do it, but you got to do it the right way. And you got to do a lot of things in filing a bankruptcy, which if you don't comply with, you're going to get kicked out of bankruptcy. So the whole filing would be a waste of time.
That's a question I had for you, if you don't mind. You mentioned earlier about talking to your bankruptcy lawyer about the different chapters before you go into it. And so if someone were, like, a lot of times we'll get the question, and recommend they talk to you guys at the Lincoln Legal Aid for help with debt. So would that be you, or how would one go about getting a bankruptcy lawyer?
Right. The only way that you're going to get advice out of me is aside from these presentations, you have to qualify as a Land of Lincoln client, which means you have to have not above a certain income and not above possessing a certain asset. And we do not count your home, by the way, as an asset. But if you own rental home property in addition to your own, that might disqualify you. If you qualify financially for us, then you get assigned the attorney in question for whatever the legal matter is, but in here, bankruptcy. So then you'd be talking to me. And by the way, let me make this clear. We represent our clients for free. So if you're talking to me about bankruptcy, you're not going to have to pay anything. And then I can chat with you about your case, just like if I was, your own hired attorney off the street, and we can decide, how to resolve the debt issues. So I can tell you this, around Central Illinois, the going rate for Chapter 7 bankruptcy attorneys, they generally charge flat fees to do a Chapter 7. They may have some additional built-on fees. Those are running in many hundreds of dollars, maybe approaching $1,000. Chapter 13 cases typically run about $3,500, although much of that will be paid as part of the plan.
Mm.
And Chapter 11s, if you do those are going to be fees that run into the thousands of dollars, 11s and 12s.
Okay,
So,
thank you. Yeah, that's a common question that we get here. And
yeah,
then you mentioned bankruptcy forms. I know you said you'd be hesitant to recommend people do that on their own, but just in case people were curious, we do help people find forms online a lot. And what are some good ways to determine whether it's an actual legitimate form? Because of course, as you might know, if you just Google bankruptcy forms, lots of things come up that don't necessarily work out for you.
what you need to do is go right to a federal bankruptcy court website. You can go Central District of Illinois Bankruptcy Court. And on that window, there's a lot of wonderful information. Along the top, there's this long tabs, and one of them is called Forms. You click on it, and then there's National Forms, and you click on it. Then you're going to be brought in this gigantic menu of forms, and then you can click on each one. You need to download it to be able to, or print it out in order to type on it. Well, you can type on it while it's there, but you can't save it. Well, once you've got all the information typed in, then you got to print it out. But that's the place to do it, right at the source, and it's any actual federal bankruptcy court website.
Okay, great, thanks. Well, those were just the questions that I had. Yeah.
Yeah, I was going to say I probably have numbed everybody else on all the information I'm dealing with.
No, I doubt that. It was a lot of good information. Yeah.
Well, hope it is useful. Again, let me bring up this. So that's my name at here, but I'm just one of, gosh, I think we have 58, 50, and now we're going to be well in excess of 60 lawyers throughout the organization, and that is not nearly enough. We get overwhelmed. So these hotline numbers that you see, the general intake hotline of this 877 number, if you're calling into that and you can't get through, don't give up. You gotta be persistent. There are many people out there that are in desperate need of legal aid and they can't afford it, and there are a few of us. So we really have to take time to parse through the cases, and we'll just be persistent. And sooner or later you will get through, and then they'll do a little intake interview to see whether you financially qualify and whether your type of case is the kind of case that we can handle. And if it is, then they'll tell you you'll be assigned an attorney who will contact you in a couple of days. So that's how we work the process.
Great, thank you. Thank you for including your information there at the end too. And I just want to remind anyone out there who watching this, if they have questions, follow-up questions, by all means, you can contact us at the library too. We can't give legal advice at the library, but we'll do what we can to point you in the right direction. And you can always call us or email us at librarian@champaign.org. Did you have any last comments to add here, Brett?
Budget. Don't spend more than you got. That's what debt's all about, right? And if you lose your job, obviously you got to keep paying stuff. Try to pare it down as much as you can, and focus on this: housing, food, home ownership. Don't pay the credit card if you can only afford to pay the rent. Don't pay the car if you can only afford to pay the rent. Tough decisions, I know, but you gotta really prioritize until you get the new income flowing again. That's my last thought, and it seems to me that's the one thing. I think a lot of bankruptcies are caused not by necessarily poor budgeting. It's caused by bad luck but it's exacerbated by poor budgeting decisions.
Yeah. Well, thank you for that advice. I want to thank you again for the wealth of information you've brought us tonight, and really appreciate your time. So that's I think that'll bring us to the end of the webinar here. And I want to thank anyone viewing here. You're more than welcome to contact us at the library and look for other events going on in the future at champaign.org/events. We've got everything from career help with interview practice happening next week to business tech, as crafty events and just fun stuff too. So thank you again, Brett, for your time. And with that, I think we'll go ahead and say good night.
Thank you very much.
Thank you.